This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Okay, the next one is performance of an existing contractual duty is not sufficient. And we're here in the 18th century, a ship case, sailing from Liverpool to the West Indies. And they sail there, and when they get there, the captain says to the crew, we've had a hard journey, so what we'll do is we'll give you 2 weeks of holiday. 2 weeks, it's called shore leave. You can spend 2 weeks on shore rather than stay on the boat. So they get to Kingston in Jamaica, and they have 2 weeks shore leave, 2 weeks holiday. And the crewmen come back, and they're counting the crewmen back onto the ship. And the first officer is counting them on 395, 396, 397. Where are the other three? And the last one on board says the other three are in that bar down the way there. And they say, go without them. They're deserting. They're not going to come back with us. So the captain says, all right, well, we'll go back to Liverpool with just 397 crew members. And one of them said, well, what about the extra work that we're going to have to do? Because we're now no longer 400, we're only 397. So this is going to involve us in additional work, and I want additional pay. And the captain agreed and said, what we'll do when we get back is you'll all get your agreed contractual pay, but then we'll get these three others, open them up, see how much they were going to be paid, and we'll divide that amongst the rest of you. It seems fair enough. Get back to Liverpool, you're all given your respective pay packets, and you open, and there's no bonus. There's no 397th share of three persons' wages. So you take the captain to court. The court says, do you get your bonus? No. You're a hard woman, Sandra. You're correct. No, you don't get your bonus. The reason is you were hired to sail from Liverpool to Kingston and back again. In the middle of the 18th century, it was accepted that crew members would die through scurvy, which is a disease, through illness, through hunger, through being swept overboard by big waves. And the only... Oh, what was that case? What was that case? Being swept overboard by a big wave. Don't say a ship case. I know it's a... sheep. The swimming sheep on the ship. Yes. What was the case? What did it illustrate? What did it illustrate? Again? Yes, that was the purpose of the pen requirement. It was to prevent the spread of disease. But what did it illustrate, Linda? Archos, which principle, which area of law are we looking at? Yes, absolutely right, Archos. Archos says it's interpretation of statute. The application of the mischief rule. That's what, well done. Interpretation of statute rules, the application of the mischief rule. And the case was Gorris and Scott, and remember the name at the back in your case lists. The name says Garrod and Scott, it should be Gorris and Scott. Where am I? Oh, when people are taken on in the middle of the 18th century to sail to Jamaica, because it's accepted that people will die and be swept overboard and fall ill, it's normal practice for the captain to employ enough people at the start to take care of this natural wastage which is going to occur during the journey there and back again. Well, it's this natural wastage. So sailing back with 397 was just as safe as sailing back with 400. In fact, there was no additional work to do. So they didn't get it. All they had done is perform their contract. They'd sailed it there and they'd sailed it back. And there was nothing additional. It was just the performance of an existing contractual duty. So they didn't get the money. Moving on, we then have the comparisons or the contrasting case. If it's over and above a natural duty, then that is okay. The case Ward and Byham. This is about a man and his girlfriend, and they had a very close relationship, as a result of which she became pregnant. So she told her boyfriend, she said, I've got some good news. I'm pregnant. And he said, I've got some bad news. I don't want to marry you. But I will do the decent thing. I will pay you £5 a week. Once the child is born, I will pay you £5 a week in support for the child. And she said, well, that's brilliant of you, thank you, because I don't really want to marry you either. But what I will do in exchange for this promise, is that I promise to look after the child, to love and to cherish it, and to keep it happy. And, a strange thing to promise, I promise that when the child is aged 21, I will give our baby the opportunity to choose which parent it wants to live with. So you've never met your father, and not you personally, you've never met your father, and suddenly you're having your 21st birthday party and your mum says, I promised your dad that I would give you the opportunity to go and live with him now you're 21. This strange person that you've never met. Do you want to go and live with a strange man that you've never met? Who deserted you before you were born? I mean, it's a really strange promise, isn't it? Yeah, I'm glad you're agreeing. I'm getting nothing, no reaction anywhere else. And I think it's most peculiar. Anyway, that's what happened. She gave birth. He paid her £5. He paid her £5. He paid her £5. And then he stopped. He said, I'm not paying you anymore. So she sued him. And he said, in his defense, he said, it is the natural duty of a mother to look after a baby. Not the man. It's the natural duty of a mother to look after the baby. All she's doing is looking after the baby. All she's doing is performing her natural duty. And that's not sufficient to merit the title consideration. And the court agreed. It is the natural duty of a mother to look at. Women's duties are children and cooking and cleaning. You have to agree, don't you, Eddie? We do agree on this. And that's the limit. Or it was in those days. It's not now. So it's the natural duty. And of course, yes, you're right. It is the natural duty of a mother to look after. But it's also not her natural duty to promise to keep the baby happy. That's over and above. That's a promise beyond the natural duty. And this undertaking, this promise to allow our child to choose who it wants to live with when it gets to 21, this is a promise over and above your natural duty. And therefore it is sufficient to merit the title consideration. And you, bastard, are going to have to pay the £5 a week until the child is 21. Yes. So he had to pay. Area of law, sufficiency of consideration. Facts, girlfriend, boyfriend, baby, keep it happy. Just summary of the facts is all you need. You remember the stories. Remember the stories. And if you remember the stories, the names will come automatically. Acts over and above a legal duty already owed is the case Glassbrook and Glamorgan. Glassbrook and Glamorgan. Glamorgan is a district in South Wales. It's a county, an area in South Wales. Glassbrook owns a coal mine. He owns a big hole in the ground where men go down and dig coal out and push it back up to the surface. And the miners wanted more money, they wanted more pay, and they were in revolts. They were going on strike because they wanted more pay, and Glassbrook said, no, I'm not paying you any more. And they were threatening. They were getting to be very aggressive. And Glassbrook was in fear for himself and his family and his property, his home and the coal mine. He was in fear that they would damage this and cause criminal damage. So he negotiated with the police that they would provide 24-hour protection, around the clock, 24/7 protection for him. And after about a month, the miners eventually went back to work and an agreement was reached with the miners. And that was it. Until Glassbrook received an invoice from Glamorgan Council. And it said, to our services in providing 24/7 protection, here's our invoice, £1,000. And he refused to pay. All you're doing is protecting the property and the lives and the health of the citizens. And that surely is what the police job is to do, is to prevent criminal damage. And they went to court, and the police successfully showed, the Glamorgan defendant successfully showed, that it's not the police duty to provide 24/7 protection. Otherwise, if all of you had your own policeman, there would be twice as many people in this room. In fact, if they also had their own policeman, there'd be 4 times as many people in this room, and so on. And it doesn't make sense that you should expect the police to provide 24/7 protection. Therefore, that is over and above their legal duty. And therefore, it is sufficient to support another contract. And therefore, they can claim their £1,000. As Glassbrook and Glamorgan acts in accordance with a legal duty, acts over and above a legal duty, Glassbrook and Glamorgan. Acts over and above a contractual duty is the next one. And this is another ship case. This is a ship sailing from Liverpool to the West Indies. And when they get to Kingston in Jamaica, the captain said 2 weeks on holiday, 2 weeks shore leave. And at the end of 2 weeks, the sailors are coming back, and the first officer is there counting the crewmen back on, and he's saying, 1, 2, 3. Where are the other 397? And number 3 said they're in that bar with those other 3 men drinking. They say, go without us. And the captain said, okay, we'll sail back with just the 3 of us. Well, that's a bit dangerous in a ship which normally has a crew of 400 to bring it back with such a minimal crew. So the crew negotiated and said, well, who's going to do the extra work and for what compensation? We'll take these pay packets and we'll distribute them and share them out amongst the 3 of you. They got back to Liverpool and they got their pay packet, but they didn't get their bonus. So they sued and they won. Of course they won. So act over and above. The captain said all you did was sail from there to there and back again. And said, yeah, but under rather different circumstances. So they did get their bonus. Now the numbers of 397 and 403, these numbers are technically not correct. They simply illustrate the point. If you were to look it up in Google, you'd find I think there were 258 crewmen sailed the boat back out of a crew potentially of 400. So although the number 3 is incorrect, it illustrates extremely the points that I'm trying to make. Okay, that was the case Hartley-Ponsonby. You may find that one a difficult name to remember. You may find all of them difficult. Hartley is actually the name of a jam, a preserve, which is the big preserve manufacturers in the UK. And there used to be a tutor at financial training called Hartley. I don't know if he's still there. The next one, Williams and Roffey. Oh, we've come across Williams before, didn't we? Where did we come across Williams? Linda? Actually, twice, if not 3 times, we came across the same Williams. Who was Williams before? Madra? Oh, Madra, don't go to sleep, please. Jana? Arthurs? It was a reward situation. The spiteful woman, the revenge, the giving information leading to the arrest of her boyfriend's brother. Williams and Carwardine. What were the other cases in the reward area? What were the other cases in the reward area? Liena? Other cases in rewards? Carlyle and Carbolic Smokeball was a reward situation. The other one, Superman. R and Clark. Yeah. Williams and Roffey. Hotel owner. Having an extension done. The agreement with the builder is that the work will be finished by the 30th of November. On the 31st October, the builder goes to the hotel owner and says, I'm sorry, but we're not going to be able to finish by the end of November. It's just not possible to finish. We've been a little bit unlucky with supply chain and a little bit unlucky with the weather, but we're not going to finish by the end of November. So I'm giving you early warning. And the hotel owner said, no, you will finish by the 30th of November. This is our contract. You will finish. I don't care what you do. I don't care how you do it, but you will finish. You can take on extra men. You can work 24 hours a day. You can work weekends. But you will finish, and I'll tell you why you'll finish. Because if you don't, you're going to destroy my business. I'm going to lose all my Christmas trade. I've got 3 weddings booked for December. I'm going to lose those. I'm going to lose all the goodwill which I've built up over years. You're going to destroy my business. You will finish. I'll pay you. I'll pay you for the extra. But you have to finish. And the builder took on extra staff, extra workers, and they did work 24 hours a day, and they did work the weekends. And on the 30th of November, the builder said, finished. We did it. I didn't think we would. There were times when I didn't think we would make it, but we finished. So, here's your invoice for the original contract price, and this is the invoice for the extra costs of employing the additional people and paying the overtime rates and working the weekends. And the hotel owner said, thank you for the first invoice, here's your payment. The second invoice, nothing. I'm not paying it. Why? Because all you've done is complete what you were originally contracted to do. You were contracted to finish the work on 30th of November, and you finished the work on 30th of November, therefore the contract price is the price I will pay. So the builder sued. Did the builder win? Okay? Probably not. Shall we go to Court of Appeal? The High Court probably said no. Let's go to Court of Appeal, shall we? Did the builder win? Yes, he did. Yes, he did. Why? What did the builder give in exchange for this promise of extra money? Again? He did. He gave something. He protected the goodwill of the hotel owner's business. He protected the hotel owner from losing the revenue from the Christmas parties and the weddings. He's protecting, he's saving for the hotel owner the potential loss that the hotel owner would otherwise have suffered. If the hotel owner had said, now listen, because I think this is great. If the hotel owner had said, you will finish, I don't care how long it takes, I will pay you the additional money, you can take on extra staff, but you must finish, and not said anything about loss of goodwill, loss of business, loss of weddings, loss of Christmas, if he'd not said anything about that, but just said to the builder, you will finish, then probably the hotel owner would not have had to pay. But because he identified to the builder all these other potential losses, then the builder knew that he was actually saving the hotel owner from suffering a loss, and therefore that was giving consideration. Williams and Roffey. Only a relatively recent case is that. Relatively recent is anything within the last 50 years, isn't it? Because some of these cases, one of these cases, we go back to the year 1604. And it's still relevant. It's still a precedent case which we still follow. So relatively recent, I suppose, would be the last 50 years. This, I think, Williamson Roffey was about 20 years ago. Thomas and Thomas. This is the second time that we've had a case where plaintiff and defendant had the same name. What was the first? What area of law did the first case illustrate where the plaintiff and the defendant had the same name? Vita, what was the case? Well done. Errington and Errington. Father, son, daughter-in-law, paying the mortgage, paying the loan, father promises to transfer the house. What's in general terms, what's the principle that this illustrates? Yes, go on. It's within the area of acceptance of contracts. You're being looked at. There are people within the room looking with fear and astonishment at the fact that you can remember. Go on, keep going. Acts of acceptance. Once you've started the acts of acceptance, the offeror cannot revoke the offer. So this is the second case where plaintiff and defendant have the same name. This is Widow Thomas, Mrs. Thomas, whose husband has died. And Mrs. Thomas was fortunate in that the husband had said within his will, he said, "It is my desire that my widow should be allowed to continue to live in the family home. It is my wish, my desire, that my widow shall continue to live in the house that we've been living in for 40 years. And she negotiated a rental payable with the executors. She negotiated the fact that she would pay rental. She was going to pay £1 per year rental. Later, in a few years' time, the children, wanting to release the capital, the equity which was fastened up in this house, said to Mum, "We want you out. We're evicting you." As you would. Get rid of your mother, put her out on the street so that you can sell the house and raise the money so that you can spend it. So they said to Mrs. Thomas, "We want you out." And she said, "No, you can't do that. It's your father's desire that I should be allowed to stay in the house." Then it went to court. And the court said, "Unfortunately, Mr. Thomas's wishes are not sufficient. Just because your dead husband wanted you to stay in the house, that's not sufficient to allow you to stay." And she said, "But I'm paying £1 a year rental." And the court said, "That's sufficient. That's enough. That's sufficient. Something of value that you're paying in exchange for being allowed to live in the house. The fact that a normal rental for a property of that nature would have been £1,000 a week doesn't matter. £1 a year is fine." So she was allowed to stay. Must be sufficient. Needn't be adequate. What adjective would you use for the sort of rent that she was paying? What would be the adjective? Rent. What would be the adjective? Again? Pepper something, yeah, pepper something. Peppercorn. And you know, that's the second time I've written pepper on the screen today. That's the second time the word pepper has appeared on the screen today. What was the first occasion? Hansard. Yes, Hansard, where in the case Pepper and Hart, the House of Lords allowed themselves to look at the daily record of things said in Parliament. And Hansard was an illustration of what? Extrinsic aids to interpretation. It's an extrinsic. It lies outside the statute, but we can look at Hansard to help us to interpret the statute. See what was being said in Parliament about this particular law in the process of it being passed. That's Thomas and Thomas. Then we get to privity. I've already mentioned privity this morning as well. No, this afternoon. I said, if I enter into a contract with Eddie, what right have you got to make me honour that contract? And that's basically what privity of contract is. It says the only people who are entitled to have any rights under a contract are the people who are a party to the contract. Only the people who are party have any right to sue or to enforce the contract. There are exceptions. The first one there, the person entitled to benefit under third-party motor insurance can sue the insurer. If you're in a car crash and it's the other person's fault, then you're in a contract with your insurer, and the other person, hopefully, is in a contract with his insurer, and therefore if his insurer is refusing to pay, your agent, your insurer, can sue his other insurer. But that's not what my contract is with my insurer, and his contract is with his insurer. So the only people entitled to sue in a contract are the people who are a party to the contract. But that's one of the exceptions, third-party motor insurance. A principal may sue to enforce a contract entered into by his agent. Agency law is a separate area of the syllabus. But an agent, just generally, just general comment, an agent is a person who is appointed by another, who's called the principal, and the principal appoints the agent to act on the principal's behalf. Typically, the agent will go and find customers for the principal's goods, and he will sell the principal's goods to the customers. He's acting like a sales representative or a sales agent, and he's selling the goods on behalf of the principal. But it is as though this agent is an extension of me, is a part of me. So if an agent enters into a contract, the principal can sue even though it's not the principal who's entered into the contract. And equally, the agent enters into a contract, the other party can sue the principal because the agent is just an extension of the principal. Are you clear on that? Are you happy with that? No, you're not happy with that? Okay, I'll appoint Benita as my agent. She's going to sell these magic pens on my behalf. She enters into a contract with you for you to buy one, and then I tell her, no, don't sell it. So you're in contract with her, but she's not able to deliver. So you can sue me instead, even though I'm not in that contract with you. My agent is in contract with you. And equally, if she does deliver and you now refuse to pay, I can sue you, even though it was not me that was in the contract.
So there should be two contracts between...
So there is an agency contract. I am in contract with my agent, and my agent, with apparent authority or due or express authority, can enter into contracts on my behalf.
Yeah, but it's only possible if the agent is authorized person?
Well, yeah, even that's not strictly correct. You say it's only possible if the agent is an authorized agent, but even that's not right, you know. Sandra, I've never appointed Sandra as my agent, but she starts selling my magic pens as well, and then she comes to me and says, you don't know me, but I've been selling your pens on your behalf. I've entered into a number of contracts for you to deliver these pens. Now, it's up to me what I want to do. I can say, who are you? Let me have a look at these contracts you've entered into. And if I like them, then even though she's not a properly authorized agent, I can adopt those contracts. If I don't like them, I can say, well, sorry, you're going to have to sort out your own troubles. I denounce you. But if the contracts are good, I can adopt them. And because you're doing better than Benita, I'll probably say, I'm sorry, Benita, I want Sandra as my agent now. So even though the agent has no authority, the principal can still adopt those contracts.
Yeah, but if I'm client, can I sue you?
No, you can't. If she has no authority and I denounce her, no, you have to sue her. But if I do adopt them, if I do ratify the contracts that she's entered into, then you sue me. Holder in due course of a bill of exchange can sue all prior parties. Bills of exchange law used to be part of the syllabus for the other qualification in the UK, and I think it's now dropped out of even their qualification. It's not part of your syllabus. Bill of exchange law is not part of your syllabus. It is part, incidentally, of the global law syllabus, but you're not doing that. So I'm not going to talk any more about what is a holder in due course. It is a technical expression, and it's basically a person who holds a piece of paper which represents money to be received in the future. Very, very simple explanation of what that is. I promise to pay Eddie $4,000 on or after 17th of March. And I can give that to Eddie, and that settles my debt. That's very, very simple. But he doesn't want to wait until the 17th of March. It's nearly a year before he gets this money. So what he can do, he can sell it. He can negotiate. He can sign on the back and say, pay Leanna, signed Eddie. And so he then gets money from Leanna. And Leanna signs it. She says, pay Ganuta, signed Leanna. And Ganuta pays Leanna money. And it just passes around. And it's just the promise of money in the future. And a person, the last person to take it under this signature, this signing on, the last person is a person called the holder in due course. And he can sue, this holder in due course can sue Ganuta, and can sue Leanna, and can sue Eddie, and can sue me. All people who previously have signed the bill in whatever capacity. The holder in due course can sue all prior parties. And Vita doesn't know Leanna, has no idea who Leanna and Eddie are, but because they've signed it, Vita, the holder in due course, can sue all these prior parties. But that's all I'm saying about holder in due course, because it's not in your syllabus. It's simply an exception to the concept of the doctrine of privity. That people, Vita is not in contract with me, I'm in contract with Eddie. Eddie's in contract with Leanna. Leanna's in contract with Ganuta. Ganuta's in contract with Vita. Vita can sue all of us.